to The Next Fight. I'm Don West, National Trial Counsel for CCW SAFE. We will continue today with our discussion of the different stages of a criminal trial, and we'll talk about the jury's deliberation, the verdict, sentencing, and an appeal. With only a few exceptions around the country, a jury verdict has to be unanimous for either guilt or innocence. If a jury can't reach a unanimous decision, and they're convinced that no matter how long they deliberate, that they never will, the judge can declare a mistrial. Judges really don't want to do this because it means that the jury is discharged without making a decision in the case, and the case will have to be retried again with a whole new jury. During the jury's deliberations, they will be able to take the evidence in the case back to the jury room with them to review. They'll be able to review audio, video recordings, for example, that have been introduced in evidence, look at photos and other physical evidence, and usually we'll have a copy of the jury instructions to review as well. However, a common misconception is that a transcript of the trial will be available for the jury to use in their deliberations. The jury won't get a transcript to review. If a jury has a question about something, they can write it down and ask the judge for an answer. The judge will confer with counsel and then decide what to do about it. The jury will elect a foreperson to preside over the deliberations like a chairperson of a meeting would. That chairperson will sign the verdict once the verdict has been reached. Jury deliberations can take several days or only a few minutes. For example, my longest deliberation in a case was 6 days, and yet the shortest was only 4.5 minutes. Waiting for a verdict in a serious case, knowing that the result could be spending the rest of one's life in prison or going free after a year-long ordeal, has to be one of the most nerve-wracking, frightening, and numbing experiences anyone can go through. Once a verdict is reached, the judge will be notified and the jury will be brought back into the courtroom. The verdict is usually handed to the judge to look it over for any irregularities and often then handed to the clerk to be published. The verdict can be guilty of the main offense, guilty of a lesser offense, or not guilty. When there are multiple charges being considered, the jury can find the defendant guilty on some charges and not guilty on others. However, all the verdicts have to be unanimous. The verdict will be published in open court. A guilty verdict in a serious case will almost always result in the defendant being remanded to custody to await sentencing, even if they've been out on bond while waiting for trial. A not guilty verdict, of course, ends the case and the defendant will be free to go to try and resume a normal life, and it won't be easy. Sentencing. A not guilty verdict cannot be appealed by the prosecutor. The concept of double jeopardy prevents an acquitted individual from being tried a second time for the same crime. Unfortunately, the courts have decided that double jeopardy doesn't apply as between state and federal courts, so it's theoretically possible that an acquitted defendant in federal court could be tried again in state court and vice versa. I've actually seen this happen a few times, but it's pretty rare. A guilty verdict on the main charge or any lesser offense will result in a sentencing hearing where the defendant will be sentenced based on the degree of crime, his or her background, and any sentencing guidelines or mandatory minimum sentences required. Some offenses, especially those where a firearm was used, may have a mandatory minimum sentence that the judge has no choice but to impose. First-degree murder may require a mandatory life sentence. Second-degree murder may not require a life sentence, but a life sentence may be able to be imposed. And lesser offenses like manslaughter or even aggravated assault can result in lengthy prison sentences. Sentencing guidelines are sentencing schemes where a sentence is recommended based on various factors like prior record, injury or death, use of a weapon, and degree of offense. When the judge has discretion to impose a sentence within a range, it's important for the defense to make an effective presentation to convince the judge to mitigate the sentence and get the best possible outcome. Often, family members will testify, employers, former teachers, and even expert witnesses on substance abuse or mental health issues will testify to help the judge have an appreciation for the actual person standing before him. Sometimes the probation department will prepare a report for the judge to consider at sentencing. It's called a pre-sentence investigation report, and its purpose is to summarize the defendant's background, education, employment history, and other relevant factors for the judge to consider. Of course, the prosecutor will also have an opportunity to present information in support of an increased sentence and may call the victim of the offense or family members to talk about the impact of the defendant's actions. After considering the evidence, the pre-sentence report, the sentencing guidelines where applicable, and any mandatory minimum sentences required by law, the judge will impose sentence. A prison sentence will be served in the state correctional system, and the defendant will be screened, classified, and designated to an appropriate facility. Short sentences of less than a year will most likely be served in the county jail. In most places, the court can include a period of probation as well to follow a prison sentence. Appeal. Within a specific time, usually around 30 days, the defendant can file an appeal. In rare situations, the judge can grant an appeal bond and the defendant can be out of jail while the appeal is pending. However, that's not common, especially in violent cases, so most people sentenced to prison will spend that time in jail waiting for their appeal to be heard. A common misperception about appeals is that the appeals court will retry the case and decide if the witnesses were truthful or not. That's just not the way it works. Appeals are to review decisions the judge made along the way and have the appellate judges decide if the trial judge made a mistake that significantly affected the fairness of the trial. Giving the wrong or misleading jury instructions can be reviewed on appeal. Decisions on what evidence to allow and what to exclude can be reviewed, or if the prosecutor made improper arguments can also be considered. The appeals court can also look at whether there was sufficient evidence presented to support the conviction. However, they don't decide which witnesses were believable. If the appeals court decides that a significant mistake was made, the recourse is for the conviction to be reversed and the case sent back to the trial court for a new trial, and then things simply start over all again. Usually, the lawyer hired for the case won't handle the appeal, or at least not without an additional fee. Likewise, if a new trial is granted, another fee will have to be paid to have the lawyer try that case again. As CCW SAFE members know, CCW SAFE provides attorney's fees for all stages of the case, including appeal and for retrial. That's a benefit that could be worth hundreds of thousands of dollars. Thanks for watching. I'm Don West for The Next Fight.